Ready? Start. The judgment of the Supreme Court of India on February 15, 2024, striking down the electoral bonds scheme is a landmark moment. Democracy requires transparency, and the fact is that the electoral bonds scheme was opaque. Voters in India have no idea who has been funding political parties and the amounts given. In all leading democracies, transparency is the basis of campaigning funding. The court has restored that transparency. There are other legal issues. The first is the limit on funding by a corporate house or organization. Again, the world over, this amount is limited to prevent undue influence on the government. We had such a provision in India before electoral bonds were introduced. The judgment says the chief reason for corporate funding of political parties is to influence the political process, which may in turn improve the company's business performance. Electoral bonds also removed the earlier limits on how much of its profits a company could donate to political parties. The scheme even allowed loss making companies to make donations. This could have opened the door for shell companies to be formed with the purpose of channeling funds to political parties. The Election Commission of India has said this opens up the possibility of shell companies being set up for the sole purpose of making donations to political parties. This too has been reversed by the court. Democracies went through a phase of crony capitalism where big money funded political parties. In return, laws, policies, schemes, and incentives were made for the benefit of the donors. In a limited way, the Supreme Court's judgment prevents this from happening in India. There was an amendment to the finance bill. In any country, the central bank alone has the authority to issue the currency such as notes and bonds. Section 31 of the Reserve Bank of India RBI Act says only the RBI or the central government authorized by the RBI Act shall draw, accept, make, or issue any bill of exchange or promissory note for payment of money to the bearers of the note or bond. The government amended the RBI Act using a Finance Act and allowed under a new clause 31(3) the central government to authorize any scheduled bank to issue electoral bonds. This amendment to the Finance Act too has been struck down. We need to pause for a minute to understand a few issues. The amendment to the RBI Act was passed in a finance bill as this does not have to be passed by the Rajya Sabha. At the time of the introduction of the electoral bonds scheme, the ruling party did not have a majority in the Rajya Sabha and wanted to avoid a vote in the upper house. But can any issue be inserted into finance bill? Electoral bonds have nothing to do with the provisions for a finance bill. Again, a number of laws were amended to introduce the electoral bonds as such as the RBI Act 1934, the Representation of the People Act RPA 1951, the Income Tax Act 1961, and the Companies Act 2013. It was carefully thought out. It was in response to a Central Information Commission CIC ruling that political parties have to be completely transparent about their funding. The electoral bonds were introduced to bypass the CIC ruling. But why are political parties afraid of transparency? The legal system remains opaque to the so called ordinary citizen and voter. When four laws are amended to introduce a scheme that strikes at a root of democracy, namely transparency, layers of obfuscation are drawn over the scheme so that the citizens give up trying to understand it. But these are not technical issues, these are issues that affect the very basis of democracy. Stop.